Okay, why don't we go ahead and get started? Thank you all so much for joining us this morning for the Teaching Movement Lawyering concurrent session. Welcome everyone and our speakers. Just a few housekeeping notes before I turn this over to our speakers. First, the session will be recorded. Feel free to leave your video off if you're more comfortable that way. Reminder that the small group sessions will meet today beginning at 12:15. And also there's 3 asynchronous videos to view on the CLIA YouTube page. So please go ahead and take a look at those. I'll put a link in the chat to those videos in just a minute. And then there are some PowerPoint slides are Google Drive, and I'll put the link to that in the chat as well so that you can access the PowerPoint. So at the we ask that you please mute yourselves unless you're asking a question, and our speakers will be answering questions. So if you just want to raise your hand, either your virtual hand or your real hand, they can call on you that way. So I just want to briefly introduce our speakers. Thank you so much, Rachel and Samir, for joining us this morning or afternoon. So Samir Ashar is Clinical Professor of Law and Associate Dean for Equity Initiatives at UC Irvine School of Law and Director of the UC Irvine Workers Law and Organizing Clinic. Rachel Lopez is Associate Professor of Law at Drexel Klein School of Law and the Director of the Andy and Gwen Stern Community Lawyering Clinic. Okay, so Rachel and Samir, I'll turn it over to you. Thank you so much again.
Just going to share my screen here.
Great. Well, thank you to the organizers of this conference, to CLIA, and especially Lauren and Wendy Vaughn for inviting us to do this. We really appreciate it. I think that I see actually that there are a number of experienced community lawyers in the room. So even though this will be a little bit of a one-way presentation, at least at the outset, we hope that we can leave time for Q&A, and we can also learn from folks who are in attendance, because there might be new clinicians, but experienced attorneys, and not even new clinicians. I see some fairly experienced clinicians as well. So we look forward for this to be a situation in which we are kind of exchanging information and knowledge rather than just passing it over in a one-way kind of method. Rachel, I don't know, did you want to talk about goals?
Sure. So yeah, again, thank you so much to the organizers, and for those that are new to the clinical community, welcome. We're so happy that you've joined, and I think you'll find that it's an incredibly supportive and kind community, one I've had the pleasure to be a part of now for 11 years. I can't believe it. So I wanted to just give you a quick sense of a roadmap for what we want to cover today. Basically sort of the tenets of the presentation is really just to give you a sense of what it means to teach movement and community lawyering. So we're going to explain what does that actually mean? What are community lawyering and movement lawyering? And how can lawyers work collaboratively with communities and movements to push for social change? And then in our particular context as teachers, what is a pedagogy that we can adapt to ensure that we're effectively balancing this need for centering communities, but also ensuring that our students are learning and getting the skills and tools they need to be effective community lawyers?
I'll just say a word on nomenclature, which is that there's a number of different names for the type of lawyering that we're going to describe in the literature. I think Rachel hews to sort of a community lawyering. I tend to think about it as movement lawyering, but as we go through the presentation, we'll try to sort of get at how the two are sort of co-constitutive and in some ways subsets of each other or with significant overlaps with each other. But there's a lot of other terms like rebellious lawyering and critical lawyering, which Layla Halas and Lindsay Harris just used in an article on critical interviewing that are out there. Collaborative lawyering, Ascanio Piamelli. But each of us kind of adopt a single term for purposes of simplicity that has a fair amount of overlap with the other models and descriptions. So I'll just say that about nomenclature. I don't think it's less important what you want to call this and more important kind of what the substance of the practice is.
Thank you so much, Samir. And I guess I'll just sort of kick it off to explain a little bit of how, and this is sort of building off a tradition of
transaction fees are super high.
Here's
So
some.
if I wanted to sell one coin, but it would cost 500.
So this sort of builds off of a tradition of mostly clinicians that have over the years developed a practice of community lawyering. And one of the things I want to be sure to center is that community lawyering and movement lawyering doesn't center a particular type or subject matter area of legal practice. It's rather an approach to legal practice that really centers building and sustaining relationships with client communities over time and in context and in part and in conjunction with community groups. So that's sort of the sort of broad strokes how we define ourselves as community lawyers.
As I mentioned earlier, I have gravitated towards movement lawyering in part because of developments in the field, and particularly the creation of the Movement Law Lab, amongst other structures, organizations that have been created to reflect what's happening on the ground. That is, in the last 11 years since Occupy Wall Street, there have been a series of social movement organizations or social movements that have arisen across subject areas, not one more in the immigrant rights context. And then as of 2014, the emergence of Black Lives Matter and the movement for Black Lives. And the Movement Law Lab really was created by Purvi Shah and other collaborators as a way to try to help define what movement lawyers do and help bring others into the fold. And so, I draw on their definition of what a theory of change might be for movement lawyers. Part of this development of movement lawyering is a response to critiques that have been made, deep critiques that have been made of public interest law, which are beset with some of the same challenges that face the nonprofit sector as a whole. The Insight Women of Color Against Violence Collective wrote a book called The Revolution Will Not Be Funded. That was expanded upon by Mananzala and Dean Spade in 2008 as well, and basically made a number of critiques of public interest law. So one is the separation of survival services from organizing. Two is the reproduction of racism, educational privilege, and classism within nonprofits and the displacement of local community leadership. Three was meeting funders' prerogatives instead of community needs and priorities. And four was the professionalization, corporatization, and competition between nonprofits. And so movement lawyering is one type of response to these critiques. I would argue that these critiques reach clinical education as well, maybe for slightly different reasons than in the NGO sector, but the focus on individual direct services separated from organizing has been a feature of clinical legal education since its founding in the 1970s. And so bringing movement lawyering into clinics in part is about advancing a different theory of change than the one advanced by mainstream legal services organizations, NGOs, and funders, And thankfully, there is now a growing kind of infrastructure to support what I would argue is a kind of recessive thread within public interest law and within clinical legal education. And so that's really what we're trying to advance in the work that both Rachel and I do, and hopefully in building alliances and infrastructure with all of you over time to kind of advance this thread of public interest law.
Yeah, and so kind of building from Samir's point of the theory of change, the focus of community lawyering, sort of the core characteristics and the ethos that develops around community lawyering really centers communities as sort of the, instead of the subjects of legal representation, really the agents of change that can drive social justice. And so the three kind of core characteristics that I would say really embody the community lawyering ethos is, you're collaborating with client communities and community leaders to identify and address collective issues. So we're not looking at issues from an individualistic or sort of, as one person's problem. The sense, even when you're doing, a more direct services, I do a combination of direct services and project work actually. You're thinking about it in terms of the collective. How do I use, even when I'm doing representation, how do I use that to ensure that it's not looking at the individual solely as one legal problem, but rather as part of a system and structure that propagates these sorts of problems. I sometimes describe to my students how a case is a symptom of a broader problem that exists. And so that helps to reframe how they understand the issues that we're grappling with, even at the end, their individual cases. The other real, I think, important difference is that the focus is on empowerment of communities and really a stronger emphasis on social and economic justice. So as opposed to sort of thinking of it in a narrow sort of political or poverty law context, really it's thinking about what are sort of the social and economic rights that need to be lifted up in order to have more healthy and robust and sustainable community relationships. And this just sort of echoes Samir's larger point that really what we're aiming to do is foster systemic and structural change. We're not looking at our clients as solely individual successes or losses in terms of their court cases, but rather how does both our project work and our casework fit into a structure that really challenges some of the very regressive laws and structures that they encounter on a regular basis.
Right. So I'm really building on Rachel's, what Rachel just said, maybe coming at it from a different angle. This sort of graphic is from the Miami Worker Center, from something that they produced in 2004, and that's been then replicated and extended and in various contexts. And really the point here is to emphasize that the work that movement lawyers do is not unlike the work that conventional attorneys, that public interest attorneys do. That is, it involves legislative work and policy advocacy, as well as litigation and engagements with government officials in various contexts. However, the ends are, I think, I would suggest, are different. And number one, and so you see that in this pyramid, the policy work, consciousness raising, and service work, all, you can imagine arrows pointing downward at the power base. That is the point of all of those tiers of work and types of work, is to build more power in the organizations with which we're collaborating. And so that means that you have to do that work, which again, there's a lot of overlap with what conventional lawyers do, in a slightly different way. And I wouldn't say slightly, maybe a significantly different way. And that means instructing students about how to do that work in a significantly different way. So here's some examples. For example, if you're involved with a community organization working on policy advocacy and trying to define legislative priorities, you have to, as a lawyer, define a participatory process that will ensure that legislative priorities are being set by your organizational collaborators. and the participants in that organization, rather than by the lawyers cutting deals with politicians in a state capital or in DC. With regard to impact litigation, there's a number of articles about challenges to the dominant mode of impact litigation. Most, kind of significantly, I would say, is Lucy White organizing on the margins of litigation. But how do you advance community objectives in impact litigation? How do you avoid the lawyers really taking over and setting aside community concerns in order to advance, the litigation as an end in and of itself in the court context? And then with regard to engagements with government officials, how do you facilitate direct client and community engagement with officials, right? So these are slightly different ways in which we would teach students to do policy work, even though there's a fair amount of overlap, again, with conventional work. Consciousness raising is not something that's normally thought of I think it comes in with regard to lawyers trying to win cases. They think, well, how can we use media advocacy in order to advance a litigation claim potentially? But here it's about training community spokespeople, undertaking community education efforts with organizers, investigating information gaps, and arming community leaders with knowledge that they can use in their advocacy and in their engagements with systems that they might be trying to change. Lawyers work with organizations to disseminate critical analyses of again, the systems that they're trying to critique and that they're trying to change. And then finally, service. I already mentioned the critique that was made by Insight and others of splitting survival services from organizing. So here, movement lawyers might represent community leaders on individual legal matters, connect individual clients to community organizations and facilitate that kind of relationship. Maybe do legal clinics at community organizations. The point is for lawyers to avoid a kind of charity or savior model of service provision. Dean Spade has recently written a book called Mutual Aid, which is really articulates this mode of service with the aim of expanding the power of community-based organizing, which I highly recommend to everybody. And then, as I said earlier, all of this work feeds into building power at the base, achieving autonomous community power by building a base and developing leadership, really trying to scale up organizations and developing the depth and capacity of grassroots leadership to ensure that it's a high quality of organizing and community leadership development. And so movement lawyers really facilitate organizational development in lots of different ways, not both through CED clinics, but also in all of our clinics when we're working with organizing groups. We help develop those organizations and promote them, and we ensure democratic accountability structures within them. Well, we can help do that at least. I'll just mention two other models in the literature that you might want to take a look at if you're interested in digging deeper. Cummings and Chen, in their book on public interest lawyering, talk about the chronological development of public interest lawyering in the latter half of the 20th century, from conventional to cause to client-centered to community lawyering. And that is I actually use that in class on lawyer-client relationships with my students. I also use Michael Grinthal, who used to be an attorney at the Urban Justice Center in New York, on models of movement lawyering. And he has four models of the sort of corporate representation, the MASH unit that's providing needed survival services to members of groups, political enabler that is facilitating relationships between the movement organization and government entities, and then litigation as scaffolding, which is advancing litigation in order to grow organizations, and finally kind of lawyer as organizer, and that's really the kind of Jerry Lopez model of rebellious lawyering and deep deep enmeshment in community. So those are a couple of other sources that you can take a look at if you want to think more about the kind of the models, as well as distribute that to students so that they could see that how some of this has developed.
Thank you so much, Samir. That was incredibly informative. Do you want to start us off on the quick write then?
Yeah. Again, if we think either in the community lawyering model, whatever you want to call it, movement lawyering, rebellious lawyering, critical lawyering, the one fundamental question is, how do we define the collective that we are attempting to work within, to be a part of, to help support with our technical legal skills and our knowledge bases. So, one way in which to ask this question is say, how do each of us define community? And Rachel and I thought it would be a great idea if folks might take a few minutes and think for yourselves, maybe do a quick write on your own computer. You don't have to share it with anybody, as to how you define community in either your past work as a lawyer, in a non-clinical setting, your current work as a fellow, or in your future work, that the clinic that you're trying to build. How do you define community? How do you define the collective that you're trying to join and raise up? What are different ways in which one might define community? And then Rachel and I will share how we define what we view as our community in a few minutes. But why don't we take maybe 2 minutes and then we'll come back. If we could come back, I think that maybe Rachel and I will share a little bit about how we think about community, but we hope that in the Q&A, we might get at some of your definitions as well, and to the extent to which you're thinking through how to define, what the community is that you are intent to engage in and be a part of. Hopefully we can have some back and forth on that, either during this session or afterwards in other types of exchanges. But Rachel, did you want to sort of post some of the ways in which we thought about community?
Sure, and I just want to make a quick point on teaching methods too, because I do this exercise with my students as well, and I ask them to think about communities that they are a part of and what defines that community. And I use this as a way to sort of elicit some of the points that we're going to discuss now, but I just wanted to share that with you because I think it's a helpful tool to get students to think a little bit more deeply about both the communities they're a part of, what distinguishes them. I even had them discuss a little bit about the norms that guide those communities. But this is just sort of a taste of the teaching methods. And I guess I should mention that I'm very happy to share any of the teaching materials that you might be interested in, because it's definitely, I've benefited from others that have shared with me, and I'm happy to pay it forward. So what we talk about is, some communities are defined because of their geographic location, their place-based, and their localness. So we might think of, and I guess I'll just throw my kind of community base. So I teach in a clinic that is focused very much on the communities that surround Drexel's campus. It's a part of a university-wide initiative to really, the goal is to sort of not be the type of university that sits on its own without any engagement with community. So they've invested in a community center that's whole mission is to sort of really collaborate with our community partners. And so in that instance, the community kind of client base that I work with is a group of neighborhoods named Mantua, West Powelton, Mill Creek that surround Drexel's campus. One thing that's tricky with that is that, the borders of these neighborhoods can be disputed. And so one of the things that we've been really mindful of is not to keep this as strict sort of borderlands because of the tricky histories involved in this. And that's sort of one of the challenges with this sort of definition. Another would be sort of identity. So, I use like the Hispanic Bar Association, which I'm a member of, to sort of, centering identity as a piece of community. A common experience, so a shared language, belief, or history of values. People can think of, for example, speaking Spanish and being part of a Spanish-speaking community as one common experience or shared language that can be a way to define a community. Also purpose, so I give the example of low-wage workers for better conditions. So you may be a workers' rights clinic, for example. Or sometimes, and this is the case with, some of the communities that I work with, I'll talk about that in a bit. Communities imposed by outside circumstances. People are assigned roles and sort of designated as being part of a community without it being a voluntary experience. So, I think of incarcerated individuals that I work with as being, one of the populations that fall into this bucket of communities.
For me, I think I've had clients that have fit all of these criteria, or each of these criteria, I should say. That is, sometimes our projects are focused on Orange County here in Irvine. Sometimes it's an individual workplace. Oftentimes it's a status, low-wage workers in a particular industry, or people enmeshed in the criminal and immigration legal systems. One note I would add here is, I think one question is like, do we like, I know that we all think that we don't necessarily have to be, quote, a part of a community in order to work within it. But I think it raises both being a part of a community. This is written about by Nancy Polikoff, complicates matters, but being apart from that community also, or that collective of interest, complicates matters. Both present complications and challenges to lawyers that we need to work with our students to understand, so that they are not blundering into situations, again, assuming that they have a degree of similarity that would obviate the need for them to think through the ways in which they're relating to collaborators. But in situations, this is talked about more, but in situations of difference, say lingual difference or racial difference, that they're not, our students and we ourselves remain vigilant not to kind of blunder into situations in which we're trampling over some of those differences without thinking about the consequences for the ways in which we're trying to build trust and to collaborate. The other thing I think of is, it's come up recently in conversations on Twitter with regard to the alliance between African Americans and Palestinians in what's happening in the West Bank, Gaza, and in Israel. And I've seen some really great definitions of solidarity. That is, it's not about the fact that we are in alliance because there's a way in which you're there for me and then I'm there for you in a kind of transactional kind of exchange. But instead, it's a kind of solidarity that's about the idea that we care about people who are maybe engaged in asymmetrical struggles against systems of power. And whatever position we ourselves occupy, we attempt to try to build alliances with those who, again, are kind of engaged in those kind of asymmetrical struggles. And we try to lend whatever whatever skills, knowledge, whatever human qualities we might bring in order to those types of struggles. And so it's a type of solidarity that is a different way to think of this than necessarily as a kind of membership, and whether we're a member of a community or we're not, and how we sort of mediate either sameness or difference. So that might be something that we continue to think about as a group, and hopefully have a little bit of time in Q&A to talk about. Again, there are complications either from an excess of similarity or sameness, and then there are also complications from difference. But I would say, based on my experience, is that folks are incredibly generous and welcoming if we are careful and we exhibit a degree of care, and we are able to build alliances and solidarities between student teams and community organizations, and between ourselves as clinical supervisors and community organizations across a range of types of identities, geographic identities, personal individual identities, racial identities, and statuses.
Yeah, and I guess I'll just add, because I really value what Samira has amplified here, and want to sort of add my own experience of working in a community now for 8 years, and sort of the difference that makes in terms of being able to really dig down into the deep issues and have the trust that's required. And I'll talk about that, giving an example of the work that I've done, but I really feel like this work, one project builds upon the next, because you sort of get deeper and deeper and deeper as you work with the group. Now, that's a challenge a bit. And I'm actually writing about this in a book chapter, because to some extent it's at odds with putting the student in the first chair, right? Which is part of the ethos of clinical teaching, is you want the students to feel like they are, sort of in charge of cases. And so I think that one of the ways that I've had to address this is be very open with the students about sort of what the process is. And I've actually found, someone asked me about this recently, I actually find that my client partners are now more excited to work with the students with me, because it's like new energy, and sort of like we built the trusting relationship, and they trust that, they've had such good experience working with students in the past, that there's sort of a track record built that makes the work with students even easier, I think.
So in terms of, I don't think that there are set steps for any of this work. Again, as experienced folks in the room know, but we would suggest that there's some ways, particularly if one is starting a practice. I think of myself starting a practice in a new geographic area that's unfamiliar to me, of ways in which to engage in community lawyering or movement-based lawyering. And the first step is to sort of locate resistance. That is, where are there groups of people that are gathering in order to organize against, again, as I said earlier, kind of engage in asymmetrical struggles against systems, against either private or public entities, in order to mitigate suffering and build power. And so I've had this experience a number of times over my career in clinical education. That is, I moved from New York to Maryland early on in the early 2000s, and I had to figure out who I was going to collaborate with. And so it may be that you have pre-existing relationships because of your prior work, your legal work in the field. I didn't have a lot of ties in Maryland, and so I kind of did the obvious, which is to kind of make a list and then to go out and meet with folks and talk to them and find out where they were, what kind of organization they were, learn from them. I actually think that this work, I did the same when I returned to New York and then when I came to California in 2011. I think this work has become a little bit easier on the movement front because of the change in politics and the change in the field. That is, there are more movement organizations in every geographic part of the United States than there has ever been in our lifetimes, I would suggest. And so, for example, in Orange County, which is, again, still a fairly conservative county, there's now an abolitionist criminal legal group called Transforming Orange County. There's a immigrant rights rapid response network in Orange County. These are organizations that didn't exist when I moved here in 2011. And so, I would suggest that actually organizations and collectives are much closer to the surface than they have been in the past. And the question is how we link up, how we find them, how we meet with them, how we build trust with them, and then how we kind of create projects then we might bring onto our dockets to get students working with them.
And, as Samir, emphasized, this isn't a list of necessarily do 1, then 2, then 3, then 4. It often happens that you're going back and forth between these different steps. We wanted to sort of at least give you a roadmap for how you might think about this as an iterative process as you go through developing your docket and your clinic. And so the second point that I think is sort of part and parcel with locating community resistance, they can, of course, it's not one step and then the next. These things go hand in hand, is this idea of slow and open listening to identify collective goals. I'm going to give an example of what that looks like with students to make it clear, but the sort of ethos behind this is that you go into meetings, especially in the beginning, without your own agenda of what you expect to accomplish at that meeting. It's really important in developing trust that the groups feel like they're the ones setting the agenda, and that you're there as not the expert, but they're the expert in educating you about what their priorities and goals are. And so that's what I really mean by slow and open listening. And students sometimes experience a little bit of anxiety around this because they feel like they have to go into these meetings with a set agenda of like, this is what we want to do. And I try to explain to them that this is sort of also a process that you can kind of think about when you're first meeting with a client. You don't always come in with a set idea when you're doing intake of like, well, this client's going to have this issue and I have to have all the answers. You're probing, you're listening, you're really trying to understand. And that's the same sort of skill set that you bring in interacting with groups. The sort of third point on here is this idea of brainstorming legal support and democratic decision-making. And so sometimes, it looks different depending on the sophistication and how, the history of your relationship with groups, of how this actually, what it looks like in practice really. But part of it is like reflecting on the collective goals that you've identified and thinking about, often alongside students, how can we bring our legal expertise to bear on the issues that are most important to the group that we're working on. And usually we try to think about not just one way that we can help, but sort of a menu of options of things. Sometimes groups come with a very specific thing that they want help on, but oftentimes, they're not entirely sure what the clinic can do for them. And so this is a really key process and sort of brainstorming, okay, this is what we can bring to this situation, and then putting this decision-making power back with the group. Okay, this is sort of, it's almost like a meeting of minds. You can kind of think of it that way, where you're trying to ascertain, well, where do the goals meet the sort of like clinical or legal training that we have? And then another key piece of this is that the implementation, it's not that they make a decision and then you go back and execute the plan and then go back to them with the final product. Really, this is a collective process in which you are sure to understand what each group brings to the table in terms of project implementation. So I just wanted to I can imagine this maybe sounds all a bit abstract. So I wanted to at least illuminate an example with a group that my clinic has worked with for about 6 years now, called the Greater Ford Think Tank. This is a think tank that is based out of SCI Phoenix. It used to be called Greater Ford, now it's called Phoenix. And it's a group of incarcerated individuals that have the mission of educating to freedom. And I first, in terms of locating resistance, I first met this group when I was being trained at Drexel to do community-based learning. We actually spent a day in SCI Greater Ford at the time and learned about this group. And I started to make the connections that so many of the members of this think tank actually came from the neighborhoods that were sort of my service neighborhood at Drexel. And in fact, one of them is now my co-author in a law review article that I wrote on the right to redemption. And so, you know, it was very generative to me to think about, this is a whole community of people that, you know, had I not engaged in this experience and asked lots of questions, I would have never known. And I would have really missed out on the opportunity for this collaboration. And so that's also, I guess, a point of locating resistance is, you know, always being attuned to the communities that you may be missing, just by nature of sort of like how you understand your positionality with community. So I'm going to talk a little bit about the experience of a particular student team that worked with the Greater Ford Think Tank, not this academic year, but last academic year. And I decided I made a really, I guess, a different choice with my clinic teams. Usually we would organize the teams for housing or criminal justice or various subject matters. And I made a change that I think has been really impactful, that now the teams are mission-based as opposed to subject matter-based. So this team, you know, working with the Greater Ford Think Tank, decide to call itself the Right to Redemption team. And this is sort of what is on the screen here is the mission statement that the think tank developed with the students, sort of to guide their work. My clinic's a year-long clinic to understand what it was that they were aiming to achieve. And at our first couple of sessions, we would go and meet with them regularly in SCI Phoenix. The questions on the table were, what is the right to redemption and what are the current barriers to the right to redemption? And I'm gonna just quickly read to you sort of like what the think tank, how they envisioned this conversation going. So they said they wanted the students to hear our group discuss, think through these topics, highlight the ways that the think tank thinks and understands these issues, allowing that to shape what the students see as the possibilities for what might be most effective and interesting for them to spend their time on for a project this year. And so that's sort of like the spirit of how we came together. And what sort of was illuminated through these conversations was, you know, a set of core beliefs that this group had, you know, a mission and a purpose for why they came together as a collective. What were their goals? What did they see as the obstacles in achieving their goals? And they said that there was a lack of nuance and complexity in the system and in the ways that we identify and address harm, particularly embodied in this false distinction between victim and offender in communities that experience multiple forms of interpersonal and structural harm. And that this us versus them system did not reflect the realities of their communities, where oftentimes families had people on both sides of you know, they lost family members to incarceration, but they also have lost family members to violent crime. They also emphasize the importance of human dignity of all human beings and how that translated into caring for others who needed their care within the prison system. So many of them, for example, provided hospice care to other terminally ill incarcerated individuals and those suffering from dementia. And so, and of course, you know, they laid out very clearly for us this understanding of the right to redemption, which is the basis of the article that I mentioned that I've co-authored with 2 members of the think tank, which is this idea that we all have the capacity for change, that this is something that is core to the human condition, and because of that is an inalienable right. And so we tried to sort of thinking of that as the ethos of this group and understanding what their mission and purpose is. We came up, the students generated a list of things that they thought would help to move these goals forward. So the first was sort of a people's guide to the clemency process, kind of thinking of the right to redemption, sort of like what is the process of sort of how to show redemption in these very intense institutional structures. We talked about, so many of them were juvenile lifers, and so we talked about writing amicus briefs on behalf of the group for cases that were challenging life without parole. We discussed with them the possibility of impact litigation that would challenge life without parole sentences for those with dementia and some of the people that they were caring for in hospice care. And we talked about sort of also a campaign that would elevate this idea that they've articulated of dual victims. So just to reiterate, this idea that there's not perpetrators and victims in the communities in which the think tank members live, but rather sort of, communities where harms are common. And so how do we work through and build a narrative? And so we went back and presented these ideas to the group. And we were actually sort of surprised by the result. We thought there was going to be a different result, but what they really wanted was the impact litigation. I think part of this was informed by their experience in the aftermath of Miller, and also sort of the daily reality of caring for people that had dementia. And so we built basically strategic litigation around this principle. The think tank, we got a bit thwarted by the pandemic, but the think tank we've developed sort of a plan for identifying plaintiffs for this case. And essentially the think tank is going to act as a next of kin for the individual and be essentially our client for this case. Hopefully we can get back on track once the pandemic is a little more calm.
I might suggest that we actually share the slides and jump to Q&A and kind of open it up.
Oh, yes.
There's a lot of, again, as wisdom in the room. So it may be that maybe we could have a few people if you want to raise your hands, if you want to comment, ask questions. And then Rachel and I can comment if it makes sense to do so. Is that all right, Rachel?
That sounds great, yeah.
Anyone have thoughts? Are you provoked by anything we've said? Are you
perplexed?
Yeah. Are there continuities with your own practice or discontinuities? How are your plans shaping up for a clinic that you might be starting or that you're already in?
What are some of the challenges you see to adopting this model in your own clinic?
Well, we could keep talking for sure. Okay. Well, well, we have a question from Julian Hill. Curious to know how you've engaged with your clinical colleagues about this approach and whether you have any success stories. So that's one question from Julian Hill in the chat. Jacqueline, did you have a comment or a question?
Yes, thanks so much, Samir and Rachel, for this presentation. It's been really helpful to me and thinking about how to engage with communities. And I wanted to ask you, Rachel, a little bit more about how do you navigate that tension that you described between representing the community and having built the trust with the community sort of yourself, and then putting the students front and center and giving the students opportunities to be involved. I work with I'm in my second year of working on a clinic that does immigration work, and one of the community organizations we really focus on working with is DACA students. It's like a DACA student campus, but I know them really well. And in part, like I represent them in their immigration cases, but some of them I don't. Some of them I just know because of their involvement in the community organization, but they really trust me and are a little wary when I try to throw them a new student every semester.
I certainly understand that challenge. I love this question because of how layered it is, because sometimes the project work here can feel really abstract, and sometimes you worry, am I actually making any strides? But this year in particular, I think there's something honestly very unique about this time, that things that we've been pushing for years and years are finally at the front of the agenda. And so I'll give you a couple of great examples about this, like the success stories, if you will. So with the think tank, one of the very first projects I did as a, a baby clinician was a case, and Samir knows this case because he probably remembers we presented together, a few years ago on this project where I was working with this group to reform the compassionate release laws. And because, the problem, basically only 12 people had been released on compassionate release. And, the think tank felt it was really inappropriate for some of these people to be in the situations that they were. And we decided to push for basically a medical parole that would allow for parole for people that didn't just have terminal illnesses, but other chronic conditions. And it seemed to get a lot of traction at first, and then it sort of fell away. But because I think of the pandemic, it's become like one of the #1 priorities of the Department of Corrections, in part because of the work that we did, quite honestly. So we made a documentary with this Penn program on documentaries in the law that featured some of our people from the client community that we serve, and sort of elevated, and this also, there's sort of other backstory about this, but it made now it's sort of one of the central priorities of the Department of Corrections, and they actually have essentially put this in their policy agenda for the year. And so it seems like it's for the first time ever possibly going to be introduced in the General Assembly. And there's both, bipartisan support for this, which hasn't in the past. The other one was a right to water project. So I encountered a number of community members that didn't have running water in their homes. And so we facilitated a right to water campaign that, of course, these things are multifaceted. So there was a media campaign. We presented it before the Mayor's Advisory Committee on Water and Food, and apparently had a big impact because I received an email this year basically saying that they want to create a permanent moratorium on water shutoffs, and that this is a direct result of the presentation that we had done 5 years ago. And so, it's just sort of like, I guess I share these stories because they were so hopeful to me that, like, this is a long game, particularly when it comes to community lawyering. And so even if you don't see immediate results, and that's something to educate the students about too, that sometimes they feel so invested in these projects and they want it to sort of like be wrapped up. And I have to explain, no, this is the long game. This is a sustained struggle that has been happening for many, many years. To get to the tension, it's definitely a real one. I think that the best way to go about it is just to be really explicit and clear with your community partners about what their expectations should be around partnering with you. And for some community groups, it's not going to be for them. They're not going to want to, have to develop that relationship with students. So I think that the most important thing is like developing a set of expectations of what this actually looks like, and being very clear and transparent about, sort of like, there's some teaching objectives that is part of this process, and most groups that I've worked with actually love working with the students. And I think that once they've sort of developed the track record of doing it, once they sort of understand and also have an amazing sense for what students can do, I've been really surprised of like almost how they have a deep sense of the pedagogy themselves after going through the process several times, and they know sort of like the appropriate scope for a project, or sort of like the ask gets sharper and sharper. So I hope that's helpful. Samir, did you have anything to add?
Yeah, and I also want to respond to some of the questions in the chat. Jacqueline, the only thing I'll say is to add to what Rachel said already about student transitions is that you just have to build trust with community partners, and then they have to trust that you're training students or working with students to make sure that they are as prepared to do the work and to sort of extend the relationship as possible. That's one piece. The other is sometimes students are ahead of me with regard to their relationships with community groups. That is, Christine in the chat asks about getting students from across the political spectrum. Increasingly, it's true that we get students who are, into conventional legal services, maybe on the more conservative political side. But then we also get students who are to the left of us now, again, increasingly because of changes in the political context. And so it could be that students actually facilitate relationships or have a kind of shared identity potentially with some of the client groups. And so it can run both ways, and it's a matter of really trying to maximize connections, relationship, and trust. I just wanted to, Julian asks about how clinical colleagues respond. I think this is related to Christine's political spectrum question. That is, I think clinical colleagues can be dubious or skeptical about a kind of more, quote, radical or left approach to lawyering or to picking clients as opposed to a first come, first serve model. That's really the kind of core legal services model that has also been a core clinical model, as I said earlier, for decades. And I think, here, I mean, I've deployed different strategies. One is let 1,000 flowers bloom. That is, my clinic does this. Your clinic, I'm not telling you how to run your clinic. You do the work the way you want to do it. If you want to do storefront, first come, first serve, that's great. That's amazing. And maybe we can collaborate because I have organizational members that need services that your clinic might provide, like a criminal justice clinic or a community economic development clinic or a DV clinic. But I'm not telling you how to, pick your cases and structure your docket. And that's just the autonomy that we have. Again, what I've suggested all along and various things that I've written and talked about is that we have much more autonomy than we think. Again, we might be differently situated politically with regard to the institutions that we work in, but we have a fair amount of autonomy that we should try to push at the bounds of. And it may be that some clinical colleagues are drawn to the model, others are repelled by it. But there's a kind of respect and base of autonomy. In terms of political spectrum, I would say that I don't make this argument that much, but I'm training lawyers to adapt or students to adapt to lawyering in the current context. And there are ways in which movement lawyering looks a lot more like, say, big firm corporate representation than individual legal services work that has been the core of the clinical model. That is, lawyers are sort of helping collectives to gain power through flexible and adaptive advocacy, right? In this case, it's at the bottom of the asymmetric relationship between systems and client groups. In the case of corporate lawyering, it's to help those with more power, but in terms of the lawyering methods, the strategic thinking and the sort of creative tactical thinking, there's actually a fair amount of transfer. Again, I don't emphasize that because I don't want to train lawyers to go out and do harm to communities. But the fact is that I'm actually having students work on complex projects that look more like the projects that they might see in private practice, as well as in helping students kind of create practices. Say you're starting a solo or small practice in a community. In a lot of ways, that looks similar to what we're doing in the clinic. Those are just some responses. David asks about how to reach a broader community and using needs assessments. I will just say that I'm wary of needs assessments. Rachel may have a different opinion about this. I really am. I am not trying to get information directly from directly impacted constituents and communities. I'm really trying to work through intermediaries, through organizers, because I think that's essential. There has to be some kind of political organizing that is an overlay. But that's my approach.
Yeah, and I think that, actually, so I did do a needs assessment, but it probably looked a lot different than kind of a classic needs assessment, in the sense of, I felt like it was really critical for me before I jumped into doing legal work with the community to really understand both the history and the demands of the client base that I was working with. And so the first year that I was at Drexel, I worked with students not to provide legal services, but rather just to sort of figure out what were the conversations that were happening in the neighborhood. So a lot of it was attending community meetings. And again, just like listening. And I have actually my students attend, they're required to just attend, almost like you would court observation, a community meeting, and just sort of write what are the dynamics, what are the concerns of the members. And really, I think helps to develop this idea of slow and open and listening. The other thing that we did was we had listening sessions that really were geared towards identifying, what were the ways that groups access lawyers, but also what were their main concerns. And part of what I learned through that process is like their main concern was actually my university. They were scared that they were going to be displaced. And so it was really important that I knew that before going in and trying to provide services, that like actually I was the enemy. I remember going in, I'm sorry to give like a war story, but I went to a community meeting and I was on the agenda to just sort of like introduce my clinic, and the person who talked before me talked about the green dragon coming to like basically put the community on fire. That's so Drexel's mascot is a dragon. And so then I had to sort of get up and talk about the clinic. And I was really glad that I had the background that I did in order to navigate some of those complexities. And I've been told that we're one of the only entities that's trusted by the community.
I think we have to wrap up. But we wanted to thank you for being able to share, and please reach out to us. We'll have our emails in the materials that are posted at the CLIA site, and also find us at conferences. And we want to support whatever it is that you're doing.
Thank you so much, Rachel. Thank you so much, Samir. We really appreciate you guys taking the time. And I will post the materials and we'll get some more information from you all. Anything you'd like to share, we'll post on the link I provided. Thank you, everyone.
Thank you so much.